Consignation. Dorothea leased portions of her 2,000 square meter lot to Monette, Caddy, Silai, and Ruth for 5 years. 2 years before the expiration of the lease contract, Dorothea sold the property to PM Realty and Development Corporation. The following month, Dorothea and PM Realty stopped accepting rental payments from all the lessees because they wanted to terminate the contract. Due to the refusal of Dorothea to accept rental payments, the lessees, Ruth et al., filed a complaint for consignation of the rentals before the RTC of Manila without notifying Dorothea. Is the consignation valid? The consignation is not valid. Article 1257 of the Civil Code provides that in order that the consignation of the thing due may release the obligor, it must first be announced to the persons interested in the fulfillment of the obligation. Moreover, Article 1258 of the same code provides that consignation having been made, the interested parties shall also be notified thereof. In this case, Dorothea, an interested party, was not notified as the consignation. The consignation is therefore not valid for non-compliance with Article 1257. Miguel's answer: consignation is not valid. For consignation to be valid, there must be initial and subsequent notification given to all interested parties. In this case, Dorothea, an interested party, was not notified, thereby making the consignation invalid. Novation. JC Construction bought steel bars from Matibay Steel Industries, which is owned by Buddy Batong Bakal. JC failed to pay the purchase materials worth $500,000 on due date. JC persuaded its client, Amoroso, with whom it had receivables, to pay its obligation to MSI. Amoroso agreed and paid MSI, or Matibay Steel Industries, the amount of 50,000 pesos. After 2 other payments, Amoroso stopped making further payments. Buddy filed a complaint for collection of the balance of the obligation and damages against JC. JC denied any liability, claiming that his obligation was extinguished by reason of novation, which took place when MSI accepted partial payments from Amoroso on its behalf. Was the obligation of JC Construction to MSI extinguished by novation? Why? No, the obligation of JC Construction to MSI was not extinguished by novation. Under Article 1292 of the Civil Code, in order that an obligation may be extinguished by another which substitute the same, it is imperative that it be so declared in unequivocal terms, or that the old and the new obligation be on every point incompatible with each other. Novation by substitution of debtor requires the consent of the creditor, as provided in Article 1923 of the Civil Code. This requirement is not present, as in this case. In Magdalena Estates versus Rodriguez, it was ruled that the mere fact that the creditor received payment from a third person does not constitute novation and does not extinguish the obligation of the original debtor. Since there was no novation, the obligation of the original debtor is not extinguished. Thus, the obligation of JC Construction to MSI subsists. Miguel's answer: the obligation of JC Construction to MSI was not extinguished. For there to be novation by substitution of the debtor, the consent of the creditor must be taken. The mere fact that MSI received payment from Amoroso does not necessarily imply that there was substitution. Fortuitous event. X. A dressmaker accepted clothing materials from Carla to make 2 dresses for her. On the day X was supposed to deliver Carla's dresses, X called up Carla to say that she had an urgent matter to attend to and will deliver them the next day. That night, however, a robber broke into her shop and took everything, including Carla's 2 dresses. X claims she is not liable to deliver Carla's dresses or to pay for the clothing materials, considering she herself was the victim of the robbery, which was a fortuitous event and over which she had no control. Do you agree? No, I do not agree. The obligation involved in this case is an obligation to do. since X's obligation is to make dresses for Carla under Articles 1167 of the Civil Code. If a person obliged to do something fails to do it, the same shall be executed at his cost. Although X may not be compelled to deliver the dresses to Carla, she may be held liable for the cost of having another person to make the dresses for Carla, which including the cost of the materials. Miguel's answer: no, I do not agree. Article 1167 of the Civil Code provides that if a person obliged to do something fails to do it, the same shall be executed at his cost. In this case, X failed to do his obligation of making the dresses of Carla. Therefore, the obligation must be executed at his cost. Furthermore, X cannot use the defense of fortuitous event as X is already in delay. According to Article 1165 of the Civil Code, if the obligor delays, he shall be responsible for fortuitous event until he has effected delivery. Requisites to a contract: consent. Jackie, 16, inherited a townhouse. Because she wanted to study in an exclusive school, she sold her townhouse by signing a deed of sale and turning over possession of the same to the buyer. When the buyer discovered that she was still a minor, she promised to execute another deed of sale when she turns 18. When Jackie turned 25 and was already working, she wanted to annul the sale and return the buyer's money to recover her townhouse. Was the sale contract void, voidable, or valid? Can Jackie still recover the property? Explain. The contract of sale is voidable where one of the parties is incapable of giving consent to a contract. The contract is voidable. Article 1390 Civil Code. It appears that only Jackie was incapacitated by virtue of her minority. Jackie cannot recover the property. First, since the contract is voidable, Jackie only had 4 years from the time she attained the age of majority to bring the action for annulment of the contract. Article 1391 Civil Code. In this case, Jackie should have brought the action for annulment of the contract within 4 years after turning 18, or up until the age of 22. Since she is already 25 years old, the period for bringing the action has prescribed. Second, Jackie may be considered to have actively misrepresented as to her age. Thus, she will be bound to the contract under the principle of estoppel. Miguel's answer: the contract is voidable since Jackie was only 16 when she entered into the contract. She was still incapable of giving her consent, thereby making the contract voidable for lack of one of the essential requisites of a valid contract. Jackie cannot recover the property anymore because the action has already prescribed. Jackie has 4 years upon reaching the age of majority to bring an action to annul the contract. More than 4 years had already passed. Action has therefore prescribed. Remission of obligation. Iya and Betty owed June $500,000 for advancing their equity in a corporation they joined as incorporators. Iya and Betty bound themselves solidarity liable for the debt. Later, Iya and June became sweethearts, so June condoned the debt of $500,000. May Iya demand from Betty $250,000 as her share in the debt? Explain with legal basis. No. Iya may not demand reimbursement from Betty. The remission of the whole obligation obtained by one of the solidary debtors does not entitle him or her to reimburse from his co-debtors. Miguel's answer: that's Article 1220. No, the condonation of the entire debt in favor of one of the creditor has the effect of extinguishing the whole debt to the benefit of his co-debtors. Article 1220. Joint and solidary obligations. Juancho, Don, and Pedro borrowed $150,000 from their friend Sita to put up an internet cafe, orally promising to pay her the full amount after 1 year. Because of her lack of business know-how, their business collapsed. Juancho and Don ended up penniless, but Pedro was able to borrow money and put up a restaurant, which did well. Can Sita demand that Pedro pay the entire obligations, since he, together with the 2 others, promised to pay the amount in full after 1 year? Defend your answer. No, Sita may not demand payment of the entire obligation from Pedro. The concurrence of two or more creditors or of two or more debtors in one and the same obligation does not imply that each one of the former has a right to demand, or that each one of the latter is bound to render entire compliance with the prestation. There is a solidary liability only when the obligation expressly so states, or when the law or the nature of the obligation require solidarity, Article 1207. In this case, there is no indication that they bound themselves solidarity to pay Sita, nor does the law or nature of the obligation require solidarity. Hence, Juancho, Don Pedro's obligation is joint, and Sita can only demand payment of 1/3 of the obligation from Pedro, which is presumed to be his share in the obligation in the absence of stipulation to the contrary. Article 1208. Miguel's answer, no. Sita may not demand payment of the entire amount from just one of the debtors. Solidary liability is never presumed. For the obligation to be considered solidary, it must be expressly specified in the agreement. There being no specification as to the nature of the liability of the debtors, it is presumed that there be joint liability. Sita can therefore only demand an amount that is in proportion to the debt of each of the co-debtor. Delay and solution indebitee. Sara borrowed 50,000 from Julia and orally promised to pay it within 6 months. When Sarah tried to pay her debt on the 8th month, Julia demanded the payment of interest of 12% per annum because of Sarah's delay in payment. Sarah paid her debt and the interest claimed by Julia. After rethinking, Sarah demanded back from Julia the amount she had paid as interest. Julia claims she has no obligation to return the interest paid by Sarah because it was a natural obligation which Sarah voluntarily performed and can no longer be recovered. Do you agree? No, I do not agree with Julia. For a creditor to be entitled to compensatory interest, the debtor must be in delay. As a rule, in order for delay to exist, demand must have been made. In this case, there was no demand made upon the expiration of the 6-month period. Thus, Sarah cannot be considered in delay and is not liable to pay compensatory interest. There being no obligation to pay compensatory interest, Julia must return the interest mistakenly paid, since she was not entitled thereto, and delivery was made merely through mistake. If something is received when there is no right to demand it, and it was unduly delivered through mistake, the obligation to return it arises. Article 2154. Miguel's answer, no, I do not agree. Julia must return the amount paid by Sarah as interest, as not doing so would amount to unjust enrichment. For interest to accrue, the debtor must be in delay, and for there to be a delay, there must be a demand. In this case, there was no demand made by Julia against Sarah. Therefore, Sarah was not in delay and is not required to pay for the interest. The interest must be returned to Sarah. Civil and natural obligations. Distinguish civil and natural obligations. Civil obligations give a right of action to compel their performance. Natural obligations, not being based on positive law, but on equity and natural law, do not grant a right of action to enforce their performance, but after voluntary fulfillment by the obligor, they authorize the retention of what has been delivered or rendered by reason thereof. Article 1423. Miguel's answer, civil obligations are obligations that can be enforced through a civil suit. It is an obligation which gives rise to a cause of action. Natural obligations, on the other hand, are obligations that do not grant a cause of action. It is an obligation that is merely based on equity. Dacian and Pago. Patch got a loan from Hagibis Corporation, but he defaulted in the payment. A case for collection of sum of money was filed against him. As a defense, Butch claims that there was already an arrangement with Hagibis on the payment of the loan. To implement the same, Butch already surrendered 5 service utility vehicles, SUVs, to the company for it to sell and the proceeds to be credited to the loan as payment. Was the obligation of Butch extinguished by reason of dash-in and pago upon the surrender of the SUVs? Decide. Miguel's answer: yes, the obligation is extinguished by reason of dash-in and pago. There is dash-in and pago when the debtor alienates property in favor of the creditor, with the consent of the latter, to satisfy monetary obligation. In this case, Butch alienated his SUVs in favor of Hagibis Corporation, and such was credited as payment for the loan that he owes the corporation. It is presumed that the loan is equivalent to the SUVs, as Hagibis and Butch had agreed to this arrangement already. Novation. Jericho, the project owner, entered into a construction contract with Ivan for the latter to construct his house. Jojo executed a surety undertaking to guarantee the performance of the work by Ivan. Jericho and Ivan later entered into a memorandum of agreement revising the work schedule of Ivan and the subcontractors. The MOA stated that all the stipulations of the original contract not in conflict with said agreement shall remain valid and legally effective. Jojo filed a suit to declare him relieved of his undertaking as a result of the MOA because of the change in the work schedule. Jericho claims there is no novation of the construction contract. Decide the case and explain. Miguel's answer: Jericho is correct. There is no novation. Novation exists when there is a change in the object, condition, or debtor, or when the terms of the old contract and the new contract are incompatible and incapable of being reconciled. In this case, the mere change in the work schedule does not render the old contract incompatible with the new contract and does not change the object of the contract, which is still to construct Jericho's house. 2016. Peter and Paul entered into a contract to sell, whereby Peter, the lot owner, agreed to sell to Paul his lot on November 6, 2016, for the price of $1 million to be paid at the residence of Peter in Makati City at 1 p.m. If the full price is paid in cash at a specified time and place, then Peter will execute a deed of absolute sale and deliver the title to Paul. On November 6, 2016, Paul did not show up and was not heard of from that date on. In view of the non-performance of Paul of his obligation, Peter sent a letter to Paul that he is expressly and extrajudicially declaring the contract to sell rescinded and of no legal and binding effect. Peter further stated that failure on the part of Paul to contest the rescission within 30 days from receipt of said letter shall mean that the latter agreed to the rescission. Paul did not reply to his letter for 5 years. Thus, Peter decided to sell his lot to Henry in 2021. After hearing that Henry bought the lot, Paul now questioned the sale of lot to Henry and files a complaint for nullification of the sale. A. Is the exercise by Peter of his power to rescind extrajudicially the contract to sell the proper and legal way of rescinding said contract? B. In case Paul made a down payment pursuant to a stipulation in the contract to sell, what is the legal remedy of Peter? Suggested answer. As a general rule, the power to rescind an obligation must be invoked judicially and cannot be exercised solely on a party's own judgment that the other has committed a breach of the obligation. This is so because rescission of a contract will not be permitted for a slight or casual breach, but only for such substantial and fundamental violations as would defeat the very object of the parties in making the agreement. However, rescission as a remedy for breach is applicable only to an obligation which is extant. Be it noted that the contract between the parties is a contract to sell and not a contract of sale, and in a contract to sell, there is reservation of ownership on the part of the seller, and his obligation to convey title will only arise upon full payment of the purchase price. Nonetheless, Peter may validly cancel the contract to sell. Olivares versus Castillo, July 9, 2014. Alternative answer: yes, Peter validly rescinded contract to sell his lot to Paul for the latter's failure to comply with his prestation to pay $1 million on November 6, 2016, at the residence of Peter so that Peter will execute the deed of absolute sale. The rescission is actually the resolution of the reciprocal obligation. In UP versus De Los Angeles, the Supreme Court ruled that the injured party may consider the contract as rescinded and act accordingly, even without prior court action. His unilateral determination, however, is provisional. Since the other party may challenge it by suing him in court, it is then the court which will finally determine if the rescission should be set aside or affirmed. Suggested answer. If Paul made a down payment on letter B, Peter may still cancel the contract because in a contract to sell, the seller does not yet agree to transfer ownership to the buyer. The non-payment of the price in a contract to sell is not a breach for which the remedy of rescission may be availed of, but rather it is considered as a failure to comply with a positive suspensive condition which will prevent the obligation of the seller to convey title from acquiring obligatory force. Orsal versus Court of Appeals. 2017. Alice agreed to sell a parcel of land with an area of 500 square meters, registered in her name and covered by TCT number 12345, in favor of Burma debt for the amount of $900,000. Their agreement dated October 15, 2015 reads as follows. I, Bernadette, agree to pay the lot owned by Alice covered by TCT 12345 for the amount of $900,000 subject to the following scheduled payment. Upon signing of agreement, $100,000, November 15, $200,000, December 15, $200,000, and January 15, 2016, $200,000, February 15, 2016, $200,000. Title to the property shall be transferred upon full payment of $900,000 on or before February 13, 2016. After making the initial payment of $100,000 on October 15, 2015, and the second installment of $200,000 on November 15, 2015, Bernadette defaulted despite repeated demands from Alice. In December 2016, Bernadette offered to pay her balance, but Alice refused and told her that the land was no longer for sale. Due to the refusal, Bernadette caused the annotation of her adverse claim upon TCT 12345 on December 19, 2016. Later on, Bernadette discovered that Alice had sold the property to Chona on February 5, 2016, and the TCT had been cancelled and another one issued, TCT 67891, in favor of Chona as the new owner. Bernadette sued Alice and Chona for specific performance, annulment of sale, and cancellation of TCT 67891. Bernadette insisted that she had entered into a contract of sale with Alice and that because Alice had engaged in double sale, should be cancelled and another title be issued in Bernadette's favor. Did Alice and Bernadette enter into a contract of sale of the lot covered by TCT 12345? Yes, they entered into a contract of sale, which is a conditional sale. That is a suggested answer. Article 1458, number 2, provides that a contract of sale may be absolute or conditional. In a contract of conditional sale, the buyer automatically acquires title to the property upon full payment of the purchase price. This transfer of title is by operation of law, without any further act having to be performed by the seller. In a contract to sell, transfer of title to the prospective buyer is not automatic. The prospective seller must convey title to the property through a deed of conditional sale, Olivares Realty Corporation in Castillo, GR 196251. In this case, it was stipulated that title to the property shall be transferred upon full payment of $900,000 on or before February 15, 2016. Thus, they entered into a conditional sale. Another suggested answer, no, because in the agreement between Alice and Bernadette, the ownership is reserved in the vendor and is not to pass to the vendee until full payment of the purchase price, which makes the contract one of contract to sell and not a contract of sale. Distinctions between a contract to sell and a contract toward sale are well established in jurisprudence. In a contract of sale, the title to the property passes to the vendee upon the delivery of thing sold. In a contract to sell, ownership is by agreement reserved in the vendor and is not to pass to the vendee until full payment of the purchase price. Otherwise stated, in a contract of sale, the vendor lost ownership over the property and cannot recover it until and unless the contract is resolved or rescinded. Whereas in a contract to sell, title is retained by the vendor until full payment of the price. In the latter contract, payment of the price is a positive suspensive condition, failure of which is not a breach but an event that prevents the obligation of the vendor to convey title from becoming effective. Saberon versus Ventanilla. In this case, the contract entered between the parties is a contract to sell because ownership is retained by the vendor and is not to pass to the vendee until full payment of the purchase price. Did Alice engage in double sale of the property? Suggested answer: no. Alice did not engage in double sale. Article 1544 of the Civil Code contemplates contracts of sale, which are absolute sales. The sale to Bernadette, however, is a conditional sale, wherein the condition was not fulfilled. In the conditional sale, the non-fulfillment of the condition prevents the obligation to sell from arising, and thus the prospective seller retains ownership without further remedies by the buyer. Since title is reserved to Alice until Bernadette pays the full price of the lot, the contract in this case is a conditional sale. Another suggested answer: no, because that's letter B. There was no previous sale of the same property prior to its sale to Chona. Despite the earlier transaction of Alice with Bernadette, the former is not guilty of double sale because the previous transaction with Bernadette is characterized as a contract to sell. In a contract to sell, there being no previous sale of the property, a third person buying such property despite the fulfillment of the suspensive condition, such as the full payment of the purchase price, for instance, cannot be deemed a buyer in bad faith, and the prospective buyer cannot seek the relief of reconveyance of the property. There is no double sale in such case. Title to the property will transfer to the buyer after registration because there is no defect in the owner-seller's title per se, but the latter, of course, may be sued for damages by the intending buyer. Coronet versus CA. Crystal owns a parcel of land covered by TCT 12345 in Angeles City. Due to severe financial constraint, Crystal was forced to sell the property to RBP Corporation, a foreign corporation based in South Korea. Subsequently, RBP Corporation sold the property to Gloria, one of its most valued clients. Wanting her property back, Crystal, learning of the transfer of the property from RBP Corporation to Gloria, sued both of them in the regional trial court for annulment of sale and for reconveyance. She alleged that the sale of RBP Corporation to Gloria was void because RBP Corporation was a foreign corporation prohibited by the Constitution from acquiring and owning lands in the Philippines. Will Crystal's suit for annulment of sale and reconveyance prosper? Crystal's suit will not prosper. The Supreme Court in Borromeo versus Descalar reiterated the consistent ruling that if land is invalidly transferred to an alien who subsequently becomes a Filipino citizen or transfer it to a Filipino, the flaw in the original transaction is considered cured and the title of the transferee is rendered valid. In this case, RBP, being a foreign corporation, is prohibited from acquiring private land, making the sale of Crystal to RBP void ab initio. However, the subsequent transfer to a Filipino citizen cured the defect, making Gloria's title valid and defeating Crystal's action for annulment and reconveyance.